Welcome to our show tonight. I'm Arthur Fite, and this is our show, Fite for Justice. I'm accompanied tonight by Freeman Fite, my son and partner, and usually the guy that tells me what I need to do when I need to do it. We do have a guest tonight, Billy Rizard, and we'll get to him in just a second. He's a certified land surveyor, and he's been surveying property in the County for a long time. I'll let him tell you about that in a minute. As you know, I hope you know, our firm does primarily litigation in the personal injury and contract disputes, divorce disputes, things like that. But in these shows, we try to bring you different subjects from time to time that we don't necessarily deal with on a daily basis. That is one of those subjects tonight, and I think you'll have some interesting conversation here about land title transfers and that sort of thing, surveying issues that come up from time to time. So tonight we're going to start out by talking about transferring title to your property. And we get a lot of questions about this over the years from people who want to know how that's done. For example, if you'll put screen number 1 up there, I'm going to start by talking about the kinds of deeds. You can transfer a title to property by a deed. And on the screen you will see these are generally the 3 kinds of deeds that transfer a title to property. This assumes that you have a seller who's named and a buyer who's named in the deed and a legal description of the property. And the 3 basic kinds are a quitclaim deed, and people say, well, what does that mean? Well, all it means is really that the seller is not giving you any warranty about the title to the property. Deeds don't ever warranty a condition of the property or defects in the property. And unless you get a warranty deed, you don't have any promises about the condition of the title. Do they own it free and clear? Are there any liens against it? That sort of thing. So oftentimes a quitclaim deed is prepared and signed in order to convey an interest in property, and all it conveys is whatever the seller owns. And he may not own anything, so he doesn't warrant he owns anything. A lot of times these deeds are done to clear up titles. There may be a problem that somebody believes that so-and-so has an interest in the property. How do we get rid of that problem? We get him to sign a quitclaim deed if we can. The second kind of deed is called a statutory warranty deed. And now what that is a limited warranty. It's by statute. That's the reason they call it statutory. And all you convey there is an interest in property, and all you warrant there is whatever interest you may own. You don't go back and warrant the whole title of the chain of title all the way back to the beginning of time. And the best deed, of course, if you're the buyer you want to get, is a general warranty deed, and this warrants that you have good title to it, there aren't any claims against it, and this is the kind of deed you'd like to get if you can, but of course it's up to the seller to decide if he's going to give you a warranty deed. Then if later there comes a problem with the title to the property, you have a claim against the seller based on the warranties in that deed, and there have been lawsuits filed based on that warranty. Now let me interject this at this point. Freeman and I are not interested in filing frivolous lawsuits or lawsuits that have no basis. We're not also interested in being trigger happy and filing lawsuits if we can resolve an issue by negotiation, by settlement, and we always try to do that first, but sometimes that's not possible. There's a big difference in opinion about what the outcome will be. That's what the court systems are designed to do, is peaceably settle disputes. For example, in your typical automobile accident case, there may be a huge difference of opinion about what the case should be settled for. And if the parties are far apart and can't come to an agreement, it's probably going to result in litigation. And so we're designed to help you do that if you have that issue. Now, in addition to transferring title by deed, there are other ways to get title to property. One of those ways, and if you'll go up on number 2, exhibit number 2, what we've listed there is a way to get title by what's called adverse possession. And at this point, Freeman's going to talk to you a little bit about adverse possession, what it means, and how you get title that way. Freeman?
Well, you can see up on the screen the listed. You have to have all of these things. It has to be actual, it has to be open and notorious, it has to be hostile, exclusive, adverse to the actual owner, continuous, and for a period of 10 years. What actual means is going to be different depending on what kind of the property it is. So if it's property where they cut timber, then possessing that actually can be just going on it every few months, cutting the timber off.
Or if it's got a house living on it.
Well, if it's got a house, then that may require that you actually live there. It may you require that you actually stay there for the period of 10 years.
Now, what we're actually talking about is you can gain title to a piece of property by adverse possession. You don't have to have a deed. So these are the things that you have to prove. And now, unfortunately, there'd be somebody else who may contest this, and he can stop you from getting title. So it almost always requires a court action to do this.
Sure. And all of these, the listed items that we have on the screen, you've got to show all of them. You can't, for instance, it's got to be open and notorious. You can't hide in the woods where someone that's inspecting property couldn't see you. And it has to be open and notorious that anyone that's inspecting the land could see you. And it has to be continuous. You can't leave for a year and then come back. The clock will start over on that 10-year period. And it has to be adverse, which means, and it can become adverse after it's permissive. If you are permissively on property for a period of time and then the owner wants you out and you don't leave, at that point it becomes adverse. And if you can stay there for 10 years, then that property can then become yours.
Yeah, you may have to go into court to establish that and get a deed to your property that way. Now, there is a third way that we're going to mention briefly about obtaining title, and it's a little bit more like, it's like adverse possession, but it's called title by prescription. Now, can you comment briefly on what that is?
All the prescription basically does is it takes the amount of years you have to have possession of the property from 10 to 20 years, and at that point, you don't really have to, it's assumed or it's presumed that you can show all of these other things.
Okay, so either of these are the ways you deed, adverse possession, or by prescription. And the best way, of course, is to get a deed to your property with appropriate legal description.
Actually purchase the property instead of squatting on land for long enough that you can take it over.
Because if you're a squatter, you can be removed by an ejectment action, which is how do you get rid of somebody. We have a Landlord-Tenant Act, which governs the possessive, permissive use of a piece of property, and it lays out a procedure for getting rid of somebody. But in this situation where you have a squatter, what do? Well, you file a suit for ejectment and you force them out, or you can go after them for trespass.
Well, we don't do much property work. One of the things that I remember from the semester of property that you get in law school was adverse possession, just because of the thought of someone, like Ted Turner, who owns hundreds of thousands of acres, and how what an ordeal it must be to go through all of that land to make sure no one is adversely possessing it.
Yeah, they got to know about it. Okay, we're ending at the end of our first segment here. We'll return in a minute with Mr. Billy Grizzard, who's seated next to me, and we're going to talk about surveying problems and issues. So stay tuned. We'll see you in a couple of minutes. Okay, welcome back to the second segment of Fight for Justice tonight. We've been talking about how you transfer title to property, or how you can acquire title to property without a deed. I also want to mention, before we go into the surveying issue, that a lot of people want to ask this question a lot: do you have to record your deed? No, you don't. To transfer title, all you have to do is give somebody a deed. You have to deliver it to them. Once you've done that, it's theirs. So why do you have to record it? Well, suppose that seller gave a deed to a second person after they gave the deed to you. That has happened. And they record their deed ahead of yours. Guess what? You don't own it, because you've got to have record title to defeat somebody else's claim. So you always race to the courthouse or the probate office to record your deed. It ought to be done within the same day or within 24 hours. And that's not much of a risk that's going to happen, but it does happen. So you want to record that deed, and it allows people checking title to make sure you've got good title or somebody else has good title to property. They can check the title history at the courthouse, find your deed, and they can find any liens that are recorded against it. Let's say this happens. You get a deed to your property, you record it, A day later, somebody comes in and records a lien or a mortgage against your property. It may have been dated before you recorded your deed, but it wasn't recorded until after you recorded your deed. Guess what? You got good title. And that person who recorded that lien or that mortgage late has got nothing. So that's why recording is so important. It's the timing of the sequence. There are other exceptions to that, which we're not going to go into tonight. But one of the things that brings up the surveying questions sometimes is a sale for division. You got multiple owners, or you've got people who have different claims to the property and you can't divide it, they can't decide on it. So what you have to do in a case like that is you file a petition in circuit court that says we can't figure out a way to divide this. If we did, we would ask our surveyor friend here to draw up how we've agreed on dividing it, and we'd do deeds that way based on the actual surveying information obtained. So if you can't do that, then you have to have a sale for division. The court orders a court-ordered sale. Instead of dividing up the property, they divide up the money from the sale. Our partition is another feature that you can use to split up property, and that's where you can partition the property into 1, 2, 3, or 4 parts, whatever the number is, but you have to be able to do it in a way that makes sense. Otherwise, you go back to sale for division. Now, when we get to partition, trying to divide up a tract, suppose you've got a 100-acre tract. One's got a nice lake, part of it's got a nice lake, one's got an old house, the rest is farmland. How do you divide that up? Well, you can agree on it, where if somebody gets more than half of it, a third of it, but they get the lake. So how do you figure out where the property line is? Well, we call on Billy Grizzard, who's seated here. We're next to me. Thank you for coming, Billy.
Thank you for having me.
Billy is a certified land surveyor, and he's done this for years. And we're going to take a little break here and go down the surveying journey. Billy, tell our audience a little about your educational background in surveying.
I began my surveying career in the Air Force. I was a geodetic surveyor. And that planted the seed for me to follow up to become a licensed surveyor in the private sector. And I've been working in Calhoun County in this area since 1973, where I was in practice with an old timer named Hank Sachs that a lot of you may know. And then I was
A.J. Sachs.
A.J. Sachs, Hank Sachs, yes. Their family developed the Sachs community primarily. And then I got my license and went out on my own in 1980, and I've been operating a private practice in land surveying since then. Becoming licensed is a really tough process. You got to have 6 years of practical experience in responsible charge, and that means that you're the one actually doing it, not the one just toting the stakes and chopping the bushes. And so then there's a rigorous examination process. It's 2 8-hour days to become licensed, and once you obtain that, then you are a licensed professional land surveyor, which I am. So that's how I began, and that's what I've been doing ever since, and been working in the Calhoun County primary area for all this time.
Okay, now let's talk about how you do your job. If somebody wants you to come survey a piece of property, what's the thing you look for first, and then how do you go about doing that survey?
If you requested me to do a survey, the first thing I'd want to know is a legal description of the property that you want surveyed, the purpose of the survey, and the intent of what we're trying to accomplish. So once you provide me with your legal description and the criteria that you want, the reason for the survey and that sort of thing, then I would go to the courthouse, as you just mentioned, research the records, obtain the legal descriptions of the adjoiners, because I'm bound to protect the adjoining property owners just as much as I am you. So in doing that, I have looked at what the records say, and then we have to go out and find prominent landmarks on the ground that we can verify and validate. And once we've found at least 2 or 3, most of the time we need 3 prominent markers, whether it be a subdivision or rural property with a section, township, and range arrangement, then we can follow the call that's listed in the deed as dictated by the measurements and the bearings and so forth that's in that.
Well, let me interrupt you. And another reason you do that is because you want to find out if people have overlapping property lines that may cause a problem, and you discover that if you got 2 different descriptions.
Many times we can determine if there's overlaps or not joining the property lines by plotting out the deeds that we acquire at the courthouse and doing our research. So yeah, that's a very common thing that we deal with to determine if they do join up properly in the manner that the descriptions call for.
Then you're okay.
Absolutely.
All right, now you mentioned trying to find a prominent marker. And if you do that, it may be I've seen these concrete monuments. The state sometimes puts out highways, sometimes way out in the country. That can be a good point to start.
It can be, but most of the time highway right-of-way markers are not that significant for beginning a survey. Primarily what we got to find is a division that goes into the section division, and finding at least one or two of those that you can verify they are what they should be.
Tell you what, why don't we put up for our audience number 4, which gives you some idea of how land is drawn up. Just describe this map you've got up there, Billy, what that means.
The original land division surveys done in the 1800s as mandated by the government was to divide into section, township, and ranges. Each section is 1 mile square, and it's divided into 4 equal parts called quarters. Each section 640 acres, and then each one of those 4 quarters are further divided into quarters again, so that each quarter is exactly 40 acres or thereabout. So that's what we're looking at is section lines, 40 lines as we refer to them, half section lines, or some of those things. So it can be an array of things, Arthur. It can be.
We're going to come back to this in a minute. We've got to take our break, and we'll discuss a little bit more detail of how that comes about. So stay tuned. We'll be right back. Welcome back to the third and final segment tonight. We're talking with Billy Grizzard, a land surveyor here in Oxford, and he's just showed you a map, or we're going to put that back up there. This is how the whole United States has been mapped out from 18-something, I believe you said. And it's from these early surveys and determinations where these boundaries are that we come down to everything. Subdivisions, lots, whatever, they all start with these survey markers. But once you get your job in hand, then you can give somebody a survey of their property, tell them where their land lines are. You can't go by some road or some ditch. Sometimes you can go by a fence line, but this is how you do it. Well, let's talk about interesting problems you encounter, Billy, in surveying. How do you survey up the side of a mountain?
That's a question that I'm asked an awful lot, and all surveys are done with horizontal distance. Horizontal distance is if everything was on a flat surface. And as you just mentioned, going up the side of a mountain or something is not a flat surface, but still, nevertheless, we take into consideration the slope up the mountain, the vertical angle of that slope, so that we can calculate the horizontal distance. So everything we do is in horizontal distance and not slope distance.
And that's the standard work of surveyors, isn't it?
That is correct, yeah,
right,
everywhere.
Well, let me raise another issue. Suppose you have a line that goes into a creek or a river. Rivers and creeks sometimes move. Their boundaries change. I mean, I know a place out in Chocolaca where Chocolaca Creek has moved over the years. How do you handle that? If your surveyor is telling you to go in the middle of Chocolaca Creek?
Well, that's a lot of things can occur, and nature is one of them. It can create. Even though the deed says to the center of the creek, it's the center of the creek regardless of where the creek is located. Although it might move, some land might be sloughed off and that sort of thing, but still you'll be going to the center of the creek regardless.
Wherever the creek is.
That's correct.
So somebody's going to gain land, somebody's going to lose land.
That's correct.
But if you have a meets and bounds, tell us what a meets and bounds description is.
A meets and bounds description is one that's tied into the sections, as I previously mentioned. All the land grant states were divided in this same manner. The original 13 states are different, and they don't have section, township, and ranges. But we use section, township, and ranges for our meets and bounds surveys, and every meets and bounds survey is tied to a section in some manner, whether it be a quarter or a half section or something to that effect.
So
and
let
that's
me follow
where
up.
most of the descriptions are.
Let me follow up on it. If you have a meets and bounds, as opposed to go to the center of the creek, then you got to measure the meets and bounds, and you may or may not be in the center of the creek, but that's where the property line's going to be. Is that right?
Well, in some cases, yeah, but if the deed explicitly says the center of the creek or the bank of the creek, then those things would be prevalent.
They would control, wouldn't they?
They would control, yes.
All right. Sometimes people ask us questions about the difference between an easement and a right-of-way. Now, you're familiar with that difference, aren't you?
I sure am.
Would you explain to our audience what the difference is between a right-of-way and an easement?
An easement is primarily deeded to someone for a specific purpose. You don't own that actual ground per se. You just own that right to do, whether it's egress, ingress, utilities, things of that nature. So primarily an easement description is prepared and it's written and it's stated for a specific purpose. Now, a right-of-way, you may own that right-of-way as part of your property description, and it will be included in what your property is and what your taxes will be paid on if it's a right-of-way. Now, there's public rights-of-way, of course, which is a little bit different, but nevertheless, a right-of-way, if it comes with your property, means that you own it. An easement, if it comes with your property, just means you have the right to do whatever that specific purpose of that easement is
All
for.
right, let me follow up with that, because this comes up occasionally. Let's suppose I buy a house out in the woods, and I've got a square acre out there, and I've got no right-of-way or no easement to get to it, but I want to get to it. Have you had that problem come up before? And I'll chime in, or Freeman can chime in, on how in the world does that landowner get to his property? He doesn't have a helicopter, so how does he do it?
That would be what we refer to as landlocked. If a person owns property and it does not touch a public way to get into the property, it'd be landlocked. And then there's several ways to go about getting a right-of-way, easement, or whatever into it. One would be the natural path that's been occurring, and if that's the case, then the adjacent property owner would have to agree to provide that for you. In some cases, it can get far enough to go to court and ask the court to grant you access to your property. And a lot of times, if that occurs, it might not necessarily be where you want access to be. It'll be where the court deems as the most easiest direct route.
And you got to pay for it.
You'd have to pay for it.
So if you're landlocked, by law in this state, you have a right to file a lawsuit to have the court declare you a right-of-way in. And then that brings up a whole lot of other issues, including paying for it. And I've had that happen 2 or 3 times over the years. But it's not a very fun kind of lawsuit. The landowner who you got to go across doesn't want you, but the court gives you a right of way, and you can imagine all the kind of interference you're going to get once you try to exercise that right. Tell us a little bit about the surveyor's right of entry.
There's a law in the state of Alabama. We're one of 15 states in the union that has a legal right of entry. That simply means that if I'm surveying the adjacent property to where you reside, and I need to go onto your property to access corners that are identifiable and verifiable, as I've shown in the section division a little earlier, then I legally have the right to do that. Now, we must, as a professional, exert whatever effort we feel is complete enough by contacting the property owner and that sort of thing. We don't have a right to damage anything on that property, and we aren't holding that person liable for any accidents that might occur while we're on that property, but we do have that right to go onto it to do what we need to do our job.
Right, let me ask you this as a practical matter. You got that right, but sometimes you have a situation where you don't want to exercise it. Let's suppose you're way out in the boondocks somewhere, and one of the characters from Duck Dynasty out there says, "You're not coming on my property to survey anything." Have you ever run into that?
Absolutely have, and the shotguns will normally prevail on it.
So that has happened, hasn't it?
Yes, it has.
So how do you resolve that?
Well, what you wind up having to do, if you can't talk to them in a reasonable manner and get them to understand what you're doing, a lot of people don't understand that the surveyor is obligated to protect the interest of the adjacent landowners just as well as the ones they're working for. Even though you're hiring me and paying me, that doesn't mean that I don't have to look out for your adjacent neighbor's property rights. So a lot of times you can explain that, and they'll resolve it and allow you to go ahead and do what you need to do, but sometimes they'll super control you. Other times it gets down to the case of where you have to go ask the judge to send, or the sheriff to send a deputy out there with you to allow you
Billy, let me
access.
interrupt you. We're getting to the end of the show. Billy Grizzard's got Grizzard Land Surveying here in Oxford. Call him if you need him, and if he can't help you, call us. We'll find a way to do it. Thank you for watching. Good night.